Well, hello, Lyric Armstrong here, your real estate agent and advocate. We are back in the Dale Warner probate matter, which I guess is Dean Warner. Dean Warner probate matter. Dale Warner is her spouse, and consequently, he is a party because they petitioned against him saying that she's dead, let's find her dead, and let's determine that, in fact, you, Dale Warner, should not be handling money. Things need to go through a conservator, needs to go through the guardianship, be approved by the court, ensure that the money that is being spent is meant to be spent according to the businesses, and all the excess is being held so that we can work out what the actual beneficiary amounts and inheritance amounts are to those particular beneficiaries. This is the lengthy process of probate. We looked at this thing months ago. I don't even know if you remember I don't remember how many months ago. It feels like it was just like the other day, but it literally was months ago. One of the last things we did on this matter was 2 or 3 months from today. Okay. So it's been a while. And that's the way court is. You go to court one day, then you set a hearing for maybe a month or so out. You might go in for that hearing. You may continue that hearing, whatever have you. The next time you come around, next thing you know, it's 3 months from the last time you were there. That is not unheard of, which is one of the reasons why I want you to avoid probate, okay? So today is going to be for all our legalese people who are just like, what's going on behind the scenes? This is really like a behind the scenes kind of hearing, because it's more towards the paperwork, more towards, civil procedure, and then it has to do with the salacious pieces of things and brings all the general public involved. So Dale is not in the stand. He's not on the stand. He's not in the courtroom. I don't see him. And the family is not there, I don't think either, maybe 1 or 2 members. But today's hearing, there's an appeals that was filed. So because there was an appeals filed, there's an automatic stay on the proceedings that's going on in the lower court, which is the probate court in this particular matter. This is different than the criminal. So criminal courts are different. We're only talking about civil, which is probate, and the appeals court for the civil court. Okay, so stay in there, hang in there. I know you know so much about the criminal matters that are going on, the fact that he was just arrested. This is the other courthouse. See, there's a lot of things going on. It's hard to do all these things at once. And it takes a great team of people. I see a new attorney. Did he fire the other one? Maybe, maybe not. We don't know. This attorney has some background in criminal law, and I think he is mainly a criminal defense attorney. So maybe he's just coming in for the fact that this particular matter is going to really reflect and have an impact on his criminal case. So consequently, they're trying to stay this particular matter by filing a motion for an appeals motion. But I think the statute is like 20 days or something. So he wants to stay the proceeding. Stay means like halt, stay right there. Don't move. Don't do nothing else. like don't stop things, red light. That's what stay is about. A motion to stay is just to hold the proceedings where they are and not to proceed just yet because something is going on that's going to affect it. We might can settle. Maybe that will be the case. This particular instance, don't know. I think it's an automatic stay because of the appeals that's going on. So let's go in and find out. We're going to go to Lenawee County and see what's happening. Oh, Judge Sally, we love her courthouse. Oh, take care of business. Make sure you click that like button. For you, like, share, and subscribe. I'm already subscribed, and let's get into court. Oh, wait, I want to make sure you can hear. Remember that. Here we go. Hey, John Holderman is in the car.
All right. Welcome, Mr. Folderman.
He's not.
Would you like to put your appearance on record?
Good afternoon, Your Honor.
Are there any litigants? Put it in the chat. Are there any one of you who are brave enough to say, I've had to go to, what is this court called? I've had to go to Zoom court and my judge would not let me be in the car. This attorney gets away with everything. A lot of attorneys do.
John Polderman on behalf of the successor conservator Charles Bullock.
Thank you. We're on record today, as you're aware, I'm sure, to review the error in the calculation of credit for time served as it relates to Mr. Dale Warner, since he was given credit for 8 days.
That's another thing. We forgot to remind you, I forgot to remind you that Dale Warner was arrested twice in this particular case. This case is not his criminal case. So now he's had the luxury of being arrested 3 times, unfortunately. But the 2 times before we're dealing with contempt. One was a civil contempt relative to documentation, not turning certain documents over. Yes, guess what? If you do not follow the judge's order to turn over documents, and the motion for sanctions gets heightened to criminal contempt. I mean, civil contempt. So there was civil contempt because you're not following the judge's order to, comply with discovery or to comply with certain matters. This particular case, oh wait, maybe these are some of the family members right here. These look like maybe some of the family members right here. I think that's her brother, I think. It's hard to tell in this light. Anyway, the thing about civil contempt is that in this probate case, it's kind of like we're going on the presumption she's kind of gone for a while. Then they said, okay, in the event that she's dead, we're going to go ahead and presume that. So consequently, Dale was operating as a husband. He was taking over what the wife would normally do, which is, no problems. If she was in the hospital incapacitated, he would have that role anyway. So that's what he was doing. However, some nefarious things became alarmed because there was closed down her particular business, opened up another business, and started funneling the same type of business through the new business, right? The same type of clientele, all those clients moved over to the new business, and he wasn't reporting those funds. So that was deemed criminal contempt. And so he was sent to jail for that. So he went to jail twice, one for not turning over documents, the other one for nefarious acts, such as looking like he was trying to hide money. Well, not him personally, but it was alluded to in the paperwork. It was stated that the design to have the new company operate was not to hide it from this particular court, but to hide it from the IRS. I don't know that if they really thought that made it any better, but anyway, that's what they said. So consequently, he went to jail twice. He ended up getting record from the jail cell, the jailhouse let him out 8 days earlier, gave him 8 days early credit because of the 8 days he spent in the civil contempt. When he had 2 separate charges, they thought they were just one charge.
As a result of we didn't do the calculation in-house. They do it across the street. So when they looked at the file, apparently what happened was they saw that he had done 8 days on contempt and saw contempt again and gave him credit for 8 days on the civil contempt towards the criminal contempt, which was obviously not appropriate. So today's hearing is to review that issue and to hear the attorney's recommendations. I wanted to clarify it for the record as to what happened. And then secondly, to allow the attorneys to be heard on any arguments that you may have as far as what should be done to remedy that at this point. Secondly, Mr. Head has raised the question of the stay, the automatic stay that's directed by the statute when there's an appeal for purposes of 21 days. I also have the motion for reconsideration. He's requested a stay past the 21 days. I had articulated that effectively I was going to make a ruling on the motion for reconsideration as well as the issue that was up for today. There is no automatic hearing on the motion for reconsideration. So I think that catches you up. Mr. Head, would you agree or disagree?
Yes, as long as we are acknowledging the fact that there is a statutory stay. Yes.
Yes, for 21, yes. You cite 600.867. I have read it. Yes.
Just clarification, I think Mr. Head has withdrawn his motion for reconsideration. That's what I heard.
I don't know if you, is that what you want to do?
Unless the court's going to set aside the judgment of contempt.
The motion for, I'm just going to cut, I'm not going to allow you to do that because I've already got an order on it. So I'll issue this.
So a motion to set aside, a motion to stay, a motion of reconsideration. Does your head hurt? Okay, a motion to stay is stop proceedings, don't do anything further. A motion to set aside is to say, okay, well, I have this order, we're gonna set this aside, we're gonna move this over, we're gonna put it kind of like in a stay, we're not gonna do anything with it. We're not gonna enforce it anymore. A motion to vacate, which is not on the books right now, but a motion to vacate is like, oh, we're gonna throw this order out, we're gonna get rid of it. So that's the difference between those. Motion to reconsider depends on what he wants to be reconsidered, such as, does he want the order to be reconsidered or something different? Probably the order. It just means, hey, Your Honor, I know that you're great and you're awesome. I think they misrepresented some set of facts to you, or you're missing a couple of statutory points, or there's some legalese or some law that's in place that you missed. So can we reconsider this particular motion with these new facts, with this new set of laws? And that is what kind of a motion to reconsider would be like. So that's the difference between the different motions that are being thrown around. And then I added the motion to vacate. That's not there. But that would be the ultimate one to say, let's just get rid of your order because the order is obsolete, it's inconsequential, it's prejudiced, it has a problem, it was probably, well, you don't want to be mean to the judge, right? You need them to side with you. But you have a pretty way of saying it. It doesn't work, it's wrong. So you say it in a very pretty way, but that's what you mean is by saying, let's vacate this order.
Today, and you'll be able to take that with you, and if the Board of Appeals doesn't like it, I'm sure they'll let me know.
And that's, okay, so I said 20 days is 21 days that the stay is statutory in Michigan. This is Michigan court, remind you. So just because the principles may be the same, the timeline is not necessarily the same. So double check with you within your own state, your own set of rules, your own civil procedure, because it may be different. And then so one of the, I guess that is, it seems like that they cut the guy off, but I think that's the original attorney that's sitting next to him. And he said, well, I think we were trying to get rid of the motion to reconsider. And he's like, yeah, if you want to do a motion to set aside. And she's like, no, we're gonna give an order on the reconsideration, because their principal understanding is that because there is a automatic stay because of the filing of the appeals court puts a stay on the proceedings so that they can review what's going on. They don't want you to do anything else. They're like, let's see if you're on the right track, kind of thing, because they filed a motion to do so. And in the appeals motion, she's going to say, I think later, that they expect for the Superior Court to have gotten to a certain point or to have a full file for them to review. And she believes the motion to reconsider is not yet had an order put on it. So the appeals won't be able to decide if it's wrong or not because there's no order entered. So she needs to enter the order. So they're going to go ahead and proceed with the actual case today.
So if I understand, Your Honor, you want us to still make a record or at least preserve arguments related to this 8-day potential
right.
issue. Okay. Well, aside from the stay, there's a doctrine called credit for time erroneously at liberty. And that has been recognized in several states, including the state of Michigan in People versus Lewandowski. That's 237, Mishap 612. It is acknowledged and recognized in the footnote in that case. It's also been recognized by the 1st, 2nd, 3rd, 5th, 6th, 7th, 8th, and 9th and 10th circuits in federal court. The doctrine is essentially coming out of the common law, and it states that a convicted person is entitled to credit against his sentence for time that he was erroneously at liberty, provided there's a showing of simple or mere negligence on behalf of the government, and provided that the day in the execution of the sentence was of no fault of the prisoner.
Okay, so that's a great argument. I like this argument. I don't know if it's applicable, but just realize that a lot of our laws in all of our states are coming from common law. So when he says it's common law, that's a basis of where our statutes come from in the first place. And then I want to say English law or Spanish law. Between the two of them, then we have our case law that also becomes a part of our law right now. So he's basically going to say this was even before we codified. This was even before we put things in statute, before we moved into our full realm of way of doing law, we had common law, and even in common law, where we took a lot of our principles from, this doctrine so existed. It's a great piece of evidence and authority, because one of the things you want to always cite in your authority is how big of an authority is it? Is it something that is outdated? So maybe that can be the argument that it's outdated, but not necessarily relative to this. Doesn't sound like that would be cool. But the other thing is it new? And if it's new, it means this is of the people now. This is what the people are, this is what the Supreme Court has just ruled. And so therefore it's new law, and it should be applied as such. But I wonder if it's just because what typically happens if you are sentenced for, let's say, assault, one case number, one particular charge, you're sentenced for it, and you have been held in jail for so many days or maybe months or years prior to going to court. You go to court and you get an order, a judgment, whatever the outcome is. They will typically credit that time that you were in jail waiting to go to court. All that time gets to be credited, and that is applicable. This is different in the sense that there was one charge for contempt of civil means, and then there became a separate charge of contempt in criminal means. So to me, those are two separate charges. Consequently, you shouldn't have credit served. But the fact that it wasn't his fault does yield to this particular defense attorney's claim. It wasn't Dale's fault that they miscalculated. It wasn't Dale's fault that they inappropriately applied his old time. So we'll see.
That's what happened here. Essentially, that's what happened in the Lewandowski case, which refers to other cases from other circuits, where a prisoner is erroneously let out of the jail or a prison through no fault of his own. In other words, if he didn't escape, that's essentially the government is stopped from playing cat and mouse with him and putting him back in jail. And he receives credit for that time that he's erroneously at liberty, as long as it's through no fault of his own. So under that doctrine, this court, should it be so inclined, and I know Your Honor has not set forth what your opinion is or what your intentions are, but if this court was inclined to make the attempt to reincarcerate him for that reason, this court cannot do so under that doctrine. Aside from that doctrine, there's waiver and estoppel. There's several courts have held that, again, when a government is stopped from playing cat and mouse, this is a direct quote, the government is not permitted to play cat and mouse with a prisoner, delaying indefinitely expiration of his debt to society and his reintegration into the free community.
Okay, so the cat and mouse thing felt a little cheeky at first, right? If you felt it, I felt it. She's making faces. So I tell you, I love this judge and her faces. Her faces are like what I feel like. What? But reality, he is citing from a case that went before the court where cat and mouse was a part of the verbiage. So he has the right to use it. It's no longer that cheeky because he's actually doing a direct quote from one of the judges at the time.
And again, that's from People versus Lewandowski, which I already cited on the record.
Lewandowski, okay.
It also was citing Dunn versus Keohane, which is 14 F3D 335 out of the Seventh Circuit Court of Appeals.
I would like for him to more Michigan.
The decision to release Dale here was not this court's, it was the jail's. Whether that was erroneous is immaterial for the purposes of our discussion here today.
Okay, so he's saying that his particular law, his particular authority is citing when the court was at error for the time the gentleman or the individual was serving. So he's saying regardless that it wasn't the court's fault and it happened to be the jail's fault, is not Dale Warner's fault. He didn't do it. So it's not his oops and problem. So he shouldn't be penalized for someone else's error, is what he's saying.
Okay. In addition to the waiver and estoppel theory and the time for erroneous at liberty theory, it's also a violation of Mr. Warner's constitutional rights, both under the United States Constitution and the Michigan Constitution to reincarcerate him at this point, that he's been let free after serving a portion of his sentence, after the court found that he was in contempt of court. More specifically, it would be a violation of Michigan Constitution, Article 1, Section 16, and the 8th Amendment of the United States Constitution, which both of which prohibit cruel and unusual punishments. And under the Michigan Constitution, it's cruel or unusual punishments. The federal Constitution is and. The idea of reincarcerating Dale is abhorrent, quite frankly.
Do you see how cute that is? It's literally a very small word that makes a huge difference. And versus or versus and. And in Michigan, it's cruel or unusual punishments. And the unusual punishment here would be, you made a clerical error as to how much time he was supposed to spend in contempt of court in jail. And consequently, he has a very great argument. This is a very great attorney. The last attorney was worse, he was blubbering as much as I am, right? If not more. And it was very hard to follow his logic. I appreciate that he finally has some Michigan law to back up a lot of his claims, since he was citing federal law and common law doctrine, which are great, but it's really more prudent to have the state law that's relative to the state that you're in, and then add on federal and all the extras. So I'm glad he's finally gotten to what Michigan law would apply, because that's what the state is bound to, is the Michigan law. And then whatever that law does not address and a federal law addresses, then you would move over to the federal law to be the authority. So cruel or unusual punishment, Article 1, Section 16 of the Michigan Constitution. That is really a great piece of evidence, a great piece of authority for him. I think that's going to make him win. Great.
And if not shocking to the conscience, I don't know what is. There's nothing more cruel or unusual than releasing an inmate, then waiting 2 weeks
Right.
after he reintegrates with his minor child, and then saying he's got to go back because somebody at the jail messed up.
Right. Exactly.
So that would certainly be unusual. I'm sure nobody in this room's heard that. And my 15 years of practice, I've never seen or heard of anything like that.
And I don't even like, and for those of you who don't know, if you gotta watch the other videos, I am not on, I don't have a side really, because I'm not in the case, so I don't have a side, but just as an opinion, as a human being, I have more sympathy towards the family, and I consider the family to be the petitioners. Dale in this situation is the respondent. He's responding to the petition. He's the defendant in this matter, if you will. It's probably just called respondent. But nonetheless, I'm not necessarily on Dale's side on most other cases, on most other hearings, mostly because the other attorney was not as articulate, not as streamlined, not as, direct, where you could follow and understand logic and agree with him. This attorney is very agreeable. That's what happens when you lean on the law and you don't over exaggerate facts, and you don't, muddle with facts so much, and you just lean on the law very hard and heavy and give the very prudent facts that support that. Very easy to follow along, and everybody can't, no one can really deny this. This is truly unusual. It's not to his fault. If someone made a clerical error and gave him credit for 8 days that he didn't necessarily deserve, you don't go ahead and I would say the same. You don't put him back in jail for that. He didn't do anything wrong.
So because of the fact that it's unusual, it's unconstitutional under the Michigan Constitution.
Mhm.
And it's also cruel and unusual under the federal Constitution. There have been some courts that have opined on that issue. For example, O'Brien versus Saginaw County, 437 F sub 582 out of the Eastern District of Michigan from 1977. The court said, in determining whether the conditions of confinement of convicted persons constitute cruel and unusual punishment, the courts have increasingly viewed the effect of the incarceration on the individual. So The prison conditions should not threaten a person's sanity, physical or mental health. And certainly releasing somebody from jail and then requiring them to go back after a period of time would certainly affect their sanity. So for all of those reasons, oh, and in addition, Your Honor, once there's been a valid sentence, the court cannot amend a valid sentence once it has started to be served. The court simply just doesn't have that ability. And that is under a court rule. And that is, I believe, that is MCR 6.429. The court may not modify a valid sentence after it has been imposed, except as provided by law.
All right, so Michigan Court Rule 6.429. Once they are serving their sentence, you cannot turn around and amend it, which I don't think she would be amending it, actually. So I don't think that's really applicable to the set of facts. That's a good piece of law to know for those who are in Michigan. And then you can see if that law applies to you in your state, if you can find it in your particular rules of court. So it'll be your state rules of court. Now, put in the comments below. I want to know, do you think this is cruel? Do you think this is unusual punishment? Do you think it's cruel and unusual punishment? Those are three different questions. So is it cruel? Like just cruel? Is it unusual, just unusual punishment? Or is it three, cruel and unusual punishment? The set of circumstances that we're talking about is that Dale, he was in jail for two different things for the same case. One was a civil contempt for not turning over documents. This was something that happened at one point in time. They came back maybe a week later, so that's probably why he had 8 days. They came back about a week or so later, a week and a half later, and they talked about him being sentenced to criminal contempt because he had done a fraudulent thing by opening up a business of a different name and funneling all of these old clients to the new business and performing the same work with the same people. All he did was put it under a new business and did not report the same to the conservator, which was supposed to be over all the financial dealings and all the inheritance that would have been for the kids. So that's why it mattered, right? This is probate. So we're not in jail, we're not in criminal court, even though there's a criminal contempt. This is still civil contempt, civil court, and it's probate. So in that sector, he got 8 days credit because the first time he went in for 8 days, they accounted it for the second time he went in, not realizing, not thinking that these are two separate charges of contempt for two separate things that he did in the same case. So he got the 8 days credit and he got out early by 8 days. So is it his fault? No, not really, right? I mean, if someone told you you have credit, you're gonna get out early, are you gonna stop them and say, wait, the judge said I had 8 more days. There's no way I'm supposed to be here. No, you're not gonna do that. You're like, oh, great. Thank you. Let me go. I want to go as soon as possible. And it's not up to you to figure out why, because that was clerical error. But do you think that's cruel to say to him now, okay, since you were let out early, you got to go back and finish your term, which is 8 more days? Or do you think it's unusual type of punishment, or is it both? And the reason is because Michigan says it has to be criminal or unusual punishment. And that's what Michigan Constitution is. The federal Constitution says cruel and unusual punishment, meaning it has to be both, right? It has to be both for one. So it's interesting. So what do you think? Tell me what you think. Put in the comment.
And again, there's no law that permits the court to amend its sentence or to reincarcerate Mr. Warner after he's been released from jail. Additionally, the credit for time served is determined by the jail. I'm not sure of a specific statute or court rule that has a uniform rule. I know that different jails have different credits that are applied for good time, and that's an issue that was that's in play here. And finally,
see if we can speed it up.
MCR 7.208 provides that once a claim of appeal has been filed, the trial court may not amend or set aside the judgment or order appealed from. So there cannot be any amendment to the sentence at this juncture. So aside from the fact that these proceedings are stayed, the court does not have the ability to reincarcerate Mr. Warner at this juncture. And we would ask for a ruling on our motion for a stay pending the outcome of the claim of appeal that we filed. So that we can get that ruling and we can present, and if it's denied, we can move the Court of Appeals for a stay pending appeal. Thank you.
Thank you. Mr. Polderman, would you like to be heard on this issue?
Yes, Your Honor. A number of things. One is the Court of
Oh,
Appeals
okay,
has jurisdiction upon.
Hey, Mr. Polderman, it's very difficult to understand you. You're breaking up a little bit. So I don't know if you could, hopefully you're safely pulled over and not actually moving at this moment.
No, he's moving.
I think we'll have to
Well,
ask you to, it's muffled. We'll come back to you in a few minutes then, once you've been able to find a safe place that you could maybe stop for a few minutes. Mr. McFarland?
I'll be at the courthouse in 5.
So be
Your
the
Honor,
court
this
of-
is not an amendment of a sentence. This is actually carrying out the sentence. that was
Thank
given by this
you.
court.
That's right.
These sites that I've heard, I haven't heard any site that's a Michigan site. I could be wrong, but these seem to be federal sites, federal court.
It's like I'm there with him. Am I in his head? I'm like, where's my Michigan? But the Constitution, he did do the Michigan, tongue tied there, huh? Michigan Constitution.
They could be used for persuasion, but we're not mandated to follow those.
That's right.
So by this reasoning, if you have somebody, I'm not saying this is this case, but if you have somebody convicted of murder and they are released, I find it hard to believe that Court of Appeals or Michigan Supreme Court is going to say this person is out free, that their time has been served. It's cruel and unusual punishment. When given a life sentence, they don't expect anything. They should expect to be released sooner. Dale Warner likewise was given a some certain sentence, Your Honor. There was a certain amount, there was a certain time. He had counsel. It was quite clear. We don't have any transcripts to indicate to the contrary, but the court was ambiguous. Matter of fact, it was very clear.
Good.
Mr. Warner have a responsibility, or at least an ability to say, I understand I was in court, I shouldn't be released as early. That's a question.
That's right. That's a question. A question, not a requirement. I truly do not. I don't know that you would. I don't know that there would be a court that require the Warner to say, "Oh no, you're letting me out early. I have so much time on my hands. Why are you letting me out early?" Now, I love his analogy. He is doing a great job at combating the set of facts that have been laid out by this particular moving party. Moving party does not mean that they have to be the actual petitioner or the plaintiff. The plaintiff starts the whole thing off. The petitioner starts it off. They do the complaint. Right? So they have the position of being the plaintiff. They are the complaining party about a particular overall issue. However, when you have motions, you can have a moving party, which can be any part of the litigants. And sometimes you have third-party litigants, which could be part of the cross complaints. They could be, connected because they're a cross complainant or they're a cross defendant, and consequently they become a moving party to a particular motion. So the moving party in this scenario is Dale Warner himself. His side is the one that's closest to us. The gentleman that's standing up right now, I believe he is the guardian for D. Warner, but he's one of the attorneys on the other side in the petitioning party sector. And I love the way he's combating the issue. He definitely is like trying his hardest. It's great. He had the ideas I had, like, where's the authority to the state? However, he didn't cite case law, but he did cite the state statute, and that is a major authority to the state. So he did give some authority to them. So it's cute. I love watching him work. He's doing a great job.
None of these cases that were cited, although I don't have copies, they haven't been
served
with me, but I don't believe that any of these cases deal with the jail's policy on releasing early or not. I think it was just a miscalculation.
Oh yeah, that's the other thing. Talking about some amendment to the sentence. The court's not amending the sentence. They're just making a question to the fact or someone's making a question to the fact that he got out early. But I love the moving parties arguments. It's like they just really, and as much as I want, I want fairness on all sides. So that's what it is. Fairness needs to be presented. Advocacy needs to be dealt with on all sides so that when the orders are set forth and when the ultimate sentencing comes down and the judgments are down, that it's, everyone got their chance and it's all good. There's no appealable issue, even though they're in appeals court right now. All right, let's hold on for just a minute. I want to fix something. Take a quick second break. Hold on. Okay, sorry about that. We are back. Let's get back into court. Here we go.
This is not a new or an amendment. This is an existing order. I think the court had the ability to issue a bench warrant as soon as it discovered that. So this is not something new. We're not halting something. There's already an order. He spends the time in jail. Probably could be clarified by a bench warrant, but the court is allowing counsel to order. I do not believe it's stayed by the appellate process, Your Honor. And that's my position.
Yes, thank you.
Okay. He did a good job at his argument. I wonder why he's sitting over here today. Usually he's back there. But I didn't hear any legalese from him either. I didn't get any authority from him either. Maybe I missed it. Maybe I forgot.
Your Honor,
Let's see what she says.
I am in agreement with Mr. McFarland on this point. I also do not believe that these proceedings are particularly stayed. I've reviewed the court rules and I can't find anything that exactly pinpoints to this type of ruling that's been made in the past in a probate proceeding. And in that regard, I defer to the court. In relation to the issue of the 8 days.
What does that mean? That means that she probably found it relating in the past to a different type of proceeding. She didn't assert that. It most likely wasn't favorable to her position. So that's she didn't assert it, but what she's also doing is trying to give the judge a means of power and authority by saying, look, judge, there's no other court that has done this before in probate. So since you are a probate judge, this is a probate matter, I defer to you, meaning I tell you that I am okay with your power being the ultimate authority in this matter, and consequently, it's your decision. That's what she's saying in summary.
That were not served by Mr. Warner. I think that it's very relevant and very pertinent to know that, by my opinion, which will be evidenced by pleadings that will be filed in this court very soon, that Mr. Warner has continually been in violation of this court's order while he was erroneously released. I do not have those ready to be filed today. Otherwise, they would have been presented to you before today. However, there are several incidences where he is attempting to operate business through the farm, where he is directing others to violate the court orders through himself and at his direction. And I believe that, in addition, I believe that his absence from this court today is further evidence of, I suppose, his inability to follow the court's order. If Mr. Warner would have been released and we wouldn't have any of these issues, if literally new information about other vehicles that are owned by the estate or in part by the estate wasn't surfacing within the last week, I would probably have a different position. Is it unfortunate for Mr. Warner that he may have to go back and serve those 8 days? Sure, it might be, but it's also unfortunate that he literally cannot help himself from violating these court's orders over and over again. So I'm asking that he be remitted back to jail, that he be ordered to serve those other 8 days. That I would ask that there's a finding that this is not an amendment of a sentence, that it's just carrying out of a valid sentence. And maybe by not ordering him back, that would be an amendment of your sentence. And because there's an appeal filed, we can't do that. So I think your only option, Judge, is to remand him back to the jail. Thank you.
Lovely set of arguments. Lovely set. This is like one of those, like I told you, this is for those legalese, geeky legalese people who are like, what's the argument? What's the letter of the law? This is for us, okay? The salaciousness and all the extras are for a different day. This hearing is for us. I love her set of arguments. She's argued the fact that there's really no precedence to this. There's nothing that happened before that we can really lean and glean from in terms of probate court. Maybe in a different court, but we're in probate court, Your Honor, and there's nothing that's been like this before. So we don't really have a law for it. We really don't have, an example for it. You were going to be setting an example in certain accents. The second thing is reminding the judge, listen, he was in contempt of court for not following your orders more than one time. And the third thing is, and guess what? He's still doing things. We're still becoming evidence of him doing things with the property that he's not allowed to do. And we're going to have to come and revisit this week. We need not stay the proceedings because there's so much to do because he's out there running amok, Your Honor. He's still doing things. And then turn around and say, and since this is not an amendment of an original order, this is the fulfillment of that order, the requirement that the full order be adhered to. Any acceptance of alteration to this order is in fact an amendment. So if you go ahead and side with him that he gets those 8-day credits and he doesn't have to go back to jail for the time that he was erroneously released, then you know what? It presents an amendment. So that in and of itself makes an amendment. Those are great arguments. I don't think it's true, but it's a great way, right? They're fighting hard. This is why attorneys can never agree, because there is always a great argument on the other side. Both sides have great arguments.
I also agree with Mr. McFarland. I agree with Ms. Berger as well. I also looked and tried to find case law and other law that would be on point here as far as the stay, given the fact that the motion for reconsideration was filed, gives the court an opportunity to correct or change or do anything that it wants to do, and then an appeal gets filed later. So I was thinking that no, would not be stayed in that circumstance because the court's going to have to rule on the motion. I defer with Ms. Berger to your Honor's judgment, and you'll know what to do. On whether or not Mr. Warner should go back for 8 days, on behalf of Angelina Warner, I have to say that no, he should not go back. She was
Okay. Hello, are you paying attention? This is the guardian over the youngest daughter, which is the daughter in common between Dale and Dee Warner. And so she has joined certain aspects of the case that are against Dale. And now her statements are, no, I don't think he should go back. Because ultimately her position is, regardless of what everyone else thinks, oh, I don't mean to be covering the judge. Her position is, regardless of what everyone else thinks, it's also what is best for her clients. All right.
be stayed in that circumstance because the court's going to have to rule on the motion. I defer with Ms. Berger to your Honor's judgment, and you'll know what to do. On whether or not Mr. Warner should go back for 8 days, on behalf of Angelina Warner, I have to say that no, he should not go back. She was delighted to have him home. She was surprised, as we all are, because she wasn't expecting him for another 8 days. But she just really, it'd be very hard on her, devastating, judging by her reaction to seeing him when she came home.
So she knew he had 8 more days. Everybody knew he had 8 more days.
That day, it would just be extremely upsetting for her, for him to go back for 8 days. That said, I leave it to the court's discretion, for the court's judgment. Thank you.
Everybody knew except for the jailhouse.
Alderman, did you want to?
Yes, Your Honor. I'm actually in the courthouse parking lot. I was able to make it here, but I would agree with what Mr. McFarland has said as far as this not being an amendment of the court's order. It would be actually just carrying out what the court had already ordered. And on this issue with the Court of Appeals having jurisdiction, MCL 600.308 provides that the Court of Appeals has jurisdiction of all final orders. The fact that the motion for reconsideration is still pending means that there is not a final order of the court at this time. So I would submit to the court that there's actually not a stay on this proceeding today, and the court should enforce its order. The fact that someone was released early does not negate a valid order of the court. And I guess if the court is still concerned about that issue, I think we should have a chance to respond in writing to these cases that Mr. Head has cited, I don't know that any of them are directly on point or speak to criminal contempt, which is a violation of the court's order, and affront to the dignity of the court. And the court has the ability to ensure that its orders are enforced and carried out. So in short, there is no stay. This court has the jurisdiction and authority to enforce its orders. There's nothing cruel and unusual about the Lenawee County Jail. That's not what's before the court today. And it's certainly not an amendment of this court's order. As Ms. Berger said, if in fact the time were shortened, that would be an amendment rather than enforcing it as written.
John Polderman coming through. This is why the judge wanted to hear from him. He's usually one of the, well, they're all great, but he is always a very poignant, particular attorney. And so he comes in with everything. And I'm glad he could hear it all in his car and remember all of his points of response, because things were in motion while he was driving and he was not taking notes. So good on him for the memory. And I love his statement. It's an affront to the dignity of the court. It's fabulous. I don't know if she's going to have the ability to run with that. That is a fabulous statement, because really what it's saying is like, it's like spitting in your face, Your Honor. That's basically what it's saying. It's like saying you have no power. It's diminishing who and what you are standing for. So an affront to the dignity of the court is a fabulous phrase. He quotes the Constitution, which most everyone does. Cruel and unusual punishment. This is what we know. If you ask someone cruel, and everyone's going to say cruel and unusual, cruel and unusual. We use the word "and" because that is in the Constitution. But there is a very, those little small words mean a heck of a big thing. One thing and the other thing. Cruel and unusual. And if the attorney is right to say that it's actually in Michigan, it's cruel or unusual, that it's one or the other. It doesn't have to be both. One or the other can help the cause. That opens it up. It opens it up really big and wide for Dale's position. So love John's ability to get in there and hammer in some great points. I just don't know how we're going to land, but like I said, that's what it's about. You have the ability for attorneys to argue the same case, the same position differently. They can argue the same position differently. They can argue different sides on the same matter. It's very easily, throwing up in the air which one's going to win.
Thank you. Go ahead.
Yeah.
Oh, great point.
With all due respect to Mr. Polderman, there is actually a court rule directly on point. That's MCR 7.208. That's the authority of court or tribunal appealed from.
Wait, what?
MCR 7.208.
MCR 7.208. Okay.
That's the authority of court or tribunal appealed from. And that says limitations, subsection A. After a claim of appeal is filed or leave to appeal is granted, the trial court or tribunal may not set aside or amend the judgment or order appealed from, except by order of the Court of Appeals or by stipulation of the parties. So,
okay, this is mute. Okay, we'll go on, but really this is a mute subject. Let's go on.
there's also criminal contempt is a crime, and therefore an order finding a party in criminal contempt of court and sanctioning the party is a final order from which a contender may appeal as of right. And that's in Ray Maroon 295 Mishaf 312 from 2012. So but because there's been a claim of appeal filed from a final order, it's very clear that a judgment of contempt is a final order. And because we have moved to withdraw the motion for reconsideration, even if the motion for reconsideration were to somehow render a final order not a final order, which is not the case, but even if it did, we've moved the court to withdraw. But that's not what the court is going to do. I understand the court's going to issue a ruling anyhow and deny it. Regardless, that order is going to be entered one way or another. And
I didn't hear him say he was doing a removal to withdraw. I remember the other attorney said, I thought you were trying to withdraw it. And then the judge was like, wait, you're trying to withdraw it. We have to move forward. What are you trying to do? And he says, well, as long as if you're gonna set aside this particular thing, then we can move on. So what is he talking about now?
The claim of appeal has been filed, and therefore this court no longer has jurisdiction to do anything with respect to that order. Especially when the statutory is in place.
Carrie
The
placed-
issue that this court may have with respect to Mr. Warner not serving what this court believes was his full sentence is between this court and the jail. It is not between this court and Mr. Warner at this juncture. He was out for a full 9 days prior to the claim of appeal being filed. And after that, now he's been out for a full 15 days. So he should receive the credit for that he deserves under the doctrine of erroneous time and liberty, which is recognized by the state of Michigan and People v. Lewandowski, as I cited. And for all the reasons I've otherwise said. The other issue is with respect to what Ms. Wilhelm indicated. It would be detrimental, it would have collateral effects to the Warner family, especially young Angelina. And it's certainly not fair to her that the jail decided to, in this court's view, release Mr. Warner early. This court knows from collateral proceedings, from other proceedings, the detrimental impact that Mr. Warner's incarceration had on Angelina, as was previously expressed in the minor guardianship case from our counselors, from the guardian ad litem, from the Department of Health and Human Services. So if this court were so inclined to believe that it does have the authority to reincarcerate Mr. Warner, I hope that this court would take that into account and consider the overwhelming and overriding collateral consequences of such a ruling. But again, for all the reasons I stated, I don't believe, with all due respect, this court has that authority at this juncture. I would be remiss not to mention, while I was not here for the prior proceedings, Mr. Warner was jailed for violating a civil court order. He was not jailed for a violent offense. He was not jailed for assault or a domestic assault or a battery or some type of a violent crime, some type of a drug crime, some type of a crime with a victim. There was not that type of an issue here. And
do you see her face? Do you see her? Me and her in the same lane. Are you trying to say that disrespecting and not abiding by the judge's order is somehow inconsequential? It's no big deal. It's not like he raped somebody or hurt somebody or killed somebody or whatever. And it wasn't just civil, it was also criminal. And the fact is, he disobeyed the judge's order. So he was held in contempt for that. But the things that he was found guilty of doing for that contempt hurts the children, hurts the heirs of D. Warner. It hurts the probate. It hurts the estate in and of itself because it's moving money. It's depleting the value of the company. It is making them inherit nothing. And in consequence, they're paying attorneys to fight for pennies. This is why you do not want to go through probate. You do not want to put your family through probate. You don't know how they're going to act when you're not here. Oh, yes, they love each other now, but will they love each other then? You don't know. You won't be here. So put it down in paper, put it in a trust, get it settled, have the beneficiaries listed, have everything of value in the trust, avoid probate at all costs. Because this now is about a year, I think. She's been, missing for over a year. They just determined that she was deceased. They have not found a body to the effect. They have determined it because there's no activity for over a year. All this is going on between the families. They believe the husband did it. They believe that their sibling is being held from them. They're not able to see their sibling. There's so much payment going on just to have this happen in probate. And you're saying to the judge who ordered him contempt that all he did was disobey you. That's no big deal. All he did was just didn't do what you told him to do. So rude. And it's all over her face, like, excuse me. It is all over her face.
While I was not present for those prior proceedings, and forgive me, I know that I don't know the entire history, it's surprising to me, because I do practice in criminal defense, that Mr. Warner was jailed for such a length of time, when I have seen, even just today, numerous dozens of criminal defendants that are charged with violent crimes that are sentenced to less.
That's when the other lady with the hair, I think her name was April from across, so she used to jump up and say, Your Honor, that's right. He was jailed for such a length of time and he's still doing things against this court order. He still hasn't learned his lesson, Your Honor.
Just the court using its equitable powers. I would hope would factor that in if the court does believe that it does have the authority to reincarcerate Mr. Warner at this juncture as well. Thank you.
All right, as it relates to the request to stay, I appreciate you bringing to the attention of the court MCR 7.208 because it does clarify, I think, in part, some of the decisions that are being submitted to the court today. For example, subsection D indicating probate actions that the probate court retains continuing jurisdiction to decide other matters pertaining to the proceeding from which an appeal was filed. There is no amendment to the opinion that the court previously ordered. This is properly considered certainly something that pertains to the proceedings from which the appeal was filed, but is not addressed in any way, shape, or form by the record. The court is also allowed to look at defects in the record under subsection C. There's also the fact that this motion for reconsideration really concerns the appeal. It has not been addressed, which would mean that we do have effectively an incomplete record for the Court of Appeals to
There's Polderman. Polderman just walked in.
review. And it does raise issues that will be addressed by the court in part, and those will be obviously very important for the Court of Appeals to consider. So for all those reasons, the court does have the authority to rule on the issues that have arisen today, including, of course, on the request for stay, which is denied. I do not think in this particular action, especially where we have the litany of examples of disregard for the court's authority by Mr. Warner up to this point, and apparently potentially continuing, that it's appropriate to allow the proceedings to stay. That creates an unreasonable barrier for those that have been appointed as conservator and attorneys to be able to properly adhere to their fiduciary and legal obligations to the estate and those that they represent. Further find that the ruling on the motion for reconsideration is appropriate to complete the record and to make a decision on the error that was made in calculation of the credit that was given to Mr. Warner. I'm not going to reincarcerate Mr. Warner. Part of the beauty, I believe, in living in the United States of America is that we do have the opportunity to look at issues of liberty, and when in doubt, we should look at them in the most civilized way as possible. In this particular situation, he certainly should have had that additional 8 days. He may, in fact, be subject to the court's proceedings again in the future, according to what I'm hearing today. So on one hand, I think it's appropriate to close the door on that issue to honor the liberties that we all adhere to and uphold in our country, frankly. That was cited in many jurisdictions on the federal circuit.
Okay, I didn't want to interrupt her too much, but that he may in fact be subject to our jurisdiction again, from what I'm hearing today, is like, hey, heads up. I think her name is April. The attorney here who got up and said that he is still doing things with the property. She was talking about the vehicles that he's not allowed to do, because he's not allowed to sell. He's not allowed to diminish the value of the business. He's not allowed to move around money. He's not allowed to change any valuations, because they're trying to determine how much goes to the beneficiaries of her heirs, right? And so you can't move stuff around, because then that changes the numbers. They don't know what's going on. And so that was like a call out. Like, if he's doing something else, then you just go right ahead and file a contempt hearing order. You go ahead and let the court know so that we can have a whole nother hearing and we can file him in a contempt again.
And so I think there's plenty of authority there, and I also don't,
Okay,
plenty of
sorry.
jurisdictions on the federal circuit. And so I think there's plenty of authority there, and I also don't, I don't believe that it serves the interests of Angelina Warner. And I also don't believe that
Oh, okay.
it was part of the intention of the court to put Mr. Warner through another arrest booking process that was not contemplated by the original order. So we will allow him to remain outside the confines of the Illinois County Jail until and unless there are issues that arise in the future. We'll close the door on that particular chapter. And finally, the court's order after the motion for reconsideration will also be issued today. And there will be an evidentiary hearing set on effectively what is the request for a Ginter hearing. So if I could ask you all to look at your schedules, I'd like to look at some dates and times for that. before we leave today.
I would ask for a finding of fault be placed on the jail. Specifically in your order, I'd like to preserve that for the record. I would also like to get that order in writing. I don't have a client. I've said that 100 times. She's not here. But I do know that if she were here, she would want the people responsible for letting Mr. Warner out of jail erroneously held accountable. And I don't know what will follow, but I'm asking for that written order today.
How would they be accountable? Can't fire, I mean, I don't know.
Frankly, I don't want to say that it's simply the jail. All of us sitting here today in this room had the ability to calculate that appropriate release date and to make sure that that was communicated effectively to the jail. Asking our jail personnel to differentiate between civil contempt and criminal contempt under the same case file number was understandably out of the ordinary for them, frankly. So I think that as much as I would love to say that it is simply their fault, I think that we all sit responsible in some part for the miscalculation. And I just want to say that, frankly, I'm glad to see that the error is made on the side of liberty rather than on the side of incarceration. That's part of, again, the reason why we have the benefits of living in this country.
America. Mhm.
So I appreciate your frustration and your request, Ms. Berger, but I'm going to deny it for those reasons.
Thank you, Judge.
Anything else?
That's it.
Okay, all right. So on the effectively what we're referring to as the Ginter hearing that was raised in the motion for reconsideration, I have Friday, December 22nd, or then I have to go into January. Any preferences?
I have court closed on December 22nd, Your Honor.
Great. Then I can clear that whole day. January it is. I can give you a. Well, let me ask you this. How much time do you think you're going to need, Mr. Knight? How many witnesses do you anticipate?
Okay.
I can think of at least 6, so we're probably gonna have, it's probably gonna be a lengthy hearing if our motion for stay pending appeal isn't granted by the Court of Appeals by that time. I think the court should at least allow the Court of Appeals that time to rule. Probably January would be more appropriate.
I would not, and that this is probably going to appear presumptuous, so I apologize to our Court of Appeals in advance. However, I have seen in other cases that for purposes of the Ginter hearing in particular, even if they granted your motion, they would be asking me to have that hearing anyway. So I would prefer to simply schedule it and get it done, rather than awaiting their directive on that point.
Understood, Your Honor.
So how about Friday, January 19th for starters?
Judge, I'm sorry, I'm out of the country.
All right, when are you back?
I'm back on that Sunday. I'm out the 18th and 19th.
I can give you a backup date on the 22nd, 23rd. And give you those 2 days as a backup to a bench trial. Is everyone clear on those 2 days?
I am.
That works for me, Your Honor.
All right, so.
I am, Your Honor, I do have a pretrial, but it is at 8 o'clock in the morning on the 23rd. That should be over now.
So if we start at 9, would that
That
accommodate
would be
that?
fine. I'm sure I'll be finished.
All right, very good. So we'll start at 9 a.m. each day, January 22nd and 23rd. I would ask that, your witness and exhibit list be filed by the end of the year. Should be easy to remember, so that we can have a look at that and determine whether or not that's gonna be enough time. Previous to that, are you available for a pretrial conference on that on Friday, January 12th at 9?
Yes, sir.
What's the time of the 22nd, Your Honor?
9 a.m. each day,
Thank
9, 9, and 9. The 12th, 22nd, and 23rd is what I'm suggesting.
Yes, the 12th, January 12th does work for me too, Your Honor.
At what time are you considering on the 12th, Your Honor?
9 a.m.
I'm available.
Any other questions? All right, thank you all for your time and your hard work on this case.
Usual, that court is stopped. Sometimes in mid-order, but they stop streaming very quickly. And yeah, we learned a lot, didn't we? So looks like there's a motion for reconsideration on the books with the appeals. There's a motion for reconsideration with the court that did not get a final judgment to it. And since they did an appeals to the circuit court or the Circuit Court of Appeals for Michigan, they are putting a automatic stay on proceedings of the lower court, which is reasonable. Like I said, it's really relative to the fact that you don't want them to continue going in the wrong direction if the appeals court sees that there's something, egregious and majorly wrong, materially of issue needs to be addressed and needs to be fixed. They only find this out if one of the parties files an appeal. Dale Warner filed an appeal. And so consequently, his attorneys are like, you have an automatic stay. And the judge says, yeah, for 21 days, but guess what? 21 days is over. Right? It's 21 days. It's not there's two defects in his argument. One, the statutory mandatory stay is for 21 days. That's probably calendar days because they just say 21 days. If it was business days, it would say 21 business days. And consequently, that's a very short period of time. It's less than a month. This case takes months and months and months to get the next hearing, as you can tell. We have another hearing coming up January 12th for pre-trial and then trial on the 22nd and 23rd of January. So that's 2 months out already. So that's more than 21 days. The other defect is the appeals is don't do anything else with, so don't do anything else. We're going to review what you have final ordered, what you have ordered in the court, what you have done and made as an order. So there's a motion for reconsideration on the books that has no final order. So the judge is saying, well, look, we have to get this done. We have to finish this because the appeals court is going to want to see what we order in order to tell us if, we're doing things right or not. And consequently, we can't just stop everything in midstream. We need to finish this particular motion because the motion is on the books, but it's in pending status. It needs to have a final order to it. It needs to be completed out. So that's why they're setting the evidentiary hearing and the trial 22nd, 23rd. Those hearings for evidentiary 22nd, 23rd, and the pretrial is January 12th. All 3 days at 9 a.m. And she's such a sweetheart. She's like, yeah, 9 a.m. for all of them. 9 a.m., 12th, 22nd, 23rd, 9 a.m. each one. And everyone was like, so what time on the 12th? 9 a.m. What time on the 22nd? Yeah, 9 a.m. So I thought, yes, 9 a.m. She's so nice. I'm like, I just said all of them or 9 a.m. It's so nice. She's like, yeah, 9 a.m. She keeps repeating herself. So we found out that the stay was denied, meaning they're not going to just stop doing anything. They need to finish the order. One of the arguments she gave the attorney is when the appeals court gets through looking at the docket and they start looking at the record, they're gonna turn around and say, what happened to the motion of reconsideration? What's the final outcome of that? And we're gonna say, well, we didn't do it because you had a motion to stay on the books. No, that's egregious. It's not good for the party. It's wasting time. So she's saying, we're gonna set this up now. We're gonna move forward with the reconsideration. He tried to withdraw. They're like, no, it's on the books. We're going to move forward, get a final order on it. So when appeals comes back and they say, what's the final order on the reconsideration? We can say, here it is. You know, we did do it. Here it is. Not to mention the stay is only 21 days. Anyway, she confirmed that there's no amendment to her order. But because it's America, she does believe in the Constitution. And I believe the Michigan Constitution is the one that prevails the most, just because it's the state constitution, but also because it's the one that has like the or and not and. And consequently, she ruled that it's not prudent to re-arrest him, and it wasn't the court's design for him to be arrested multiple times for this one occurrence. And like I said, he had 2 separate charges. His first time was contempt for civil impropriety actions of, the documents. And the second was criminal, because he had done something that was considered fraudulent by opening up a business and moving money around. That became a criminal contempt. And she feels it's very unnecessary for us to think that the jailhouse should have been able to tell the difference. It had the same case number. That's the thing. It had the same case number. It's the same person. They're coming back for contempt. And now you want them to be very small and say, wait, is this one civil and criminal? You have to make it simple and big and bold for them to know. And that's when the I think Miss April came up and said she wanted to do what did she call it? She wanted a ruling against the jailhouse for their miscalculation. Can't remember what she called it. And the judge gave her a very nice no. It was like, basically, all of us should have did this, and we didn't do it. And that's the thing. We can say to ourselves, that's not my job. My job is not to calculate time. I don't do that. But, and that's for any part of legal. That's the secretary, the receptionist, the paralegal, the attorney. I can't tell you how many people say, I'm not the attorney. I don't have to do that. I'm not the paralegal. That's something. I'm not the secretary. I'm not the receptionist. I don't need to answer the phones. Well, guess what? This is what can happen. If you don't fill in the gaps and make it simple and make it as plain as day for the next person, then you can miss an opportunity. You don't answer that phone because the receptionist's not at the desk and that's not your job. That could be the $1 million client calling that wants to move their business. No one's ever answering the phone, right? Answer the phone. I don't care whose job it is. You're not picking up the trash because you're not the janitor. Guess what? It's trash down there. Pick it up. Put it in the trash can, right? You do the work because you're there for the company as a whole. And that's the same thing here. The judge was right. I tell you, all arguments were great. You could be like, oh, that was a great one. I'm on this side. Oh, wait, it's a great one. I'm on this side. You could just be yanked around all around. You could be in a roller coaster ride because all of the arguments were great. Everyone, Holderman came in with fabulous wording. He was poignant. He was right on purpose. I love his statement. I've written it down up front to the dignity of the court. Love it. This is something we can use forever. This is great, right? And if you do an action now, you're actually putting an amendment to your order. That was April's argument. Love that one too. But prevailing argument seemingly was Michigan Constitution, right? Cruel or unusual. Like now we got to go look at every state constitution. Who has cruel and versus who has cruel or unusual? We need to find out. We got to find out what states are going by or, because it's a major difference. It's a major, small words can make big impacts. And that definitely is the case there. And the judge was going on about, the judge didn't put a certain date down. She put a time. Gotta be, I think she said 15 days. I think it was 15 days he was ordered. Whatever, she put a time down. And there was no calculations to which day should he be released. And so the jailhouse had to do the calculation. You left it to them to do the calculation. They made the error, but you didn't give them a different directive. They didn't disobey you. They just made an error. They gave credit where credit was not necessarily supposed to be applied. So, oh well, now we know for future. Every attorney has learned, every paralegal has learned, we have all learned. We pull out our calendars and we say, hey, judge, that means if he goes in today, 15 days from today, he's out in 2 weeks plus 1, right? So such and such day is his release day. Is that correct? And make that in the order. Have that articulated in order. We now know why, because it's an honest mistake can be made. Oh, another thing that she said, subsection C for the appeals, is that this is what the judge was articulating, is that the court may review defects of the record. So even if you had a stay on the proceedings, if you're not allowed to continue proceedings and having hearings and going through and continue shop, you were still allowed to review for the defects. And one of the defects that this record has is that they don't have a final judgment. And the appeals court can only have a finding and a ruling and a review of what has been judged upon, what has been finally judged. So that's the defect. And consequently, she's going to clear that defect by moving forward with the dates that she gave. Let's see. Yeah, that's. And then she kept giving them hints. She just kept saying, okay, based on Warner's actions, looks like we may be reviewing this in the future. Meaning to say, just because, we're not putting him back in jail for this particular contempt, he just might be in contempt in a few more weeks, because in a few months, because seems like he's doing too much already. All right, so this is just a continuation of what we learned. How did we get here? We're real estate attorney. We're looking for real estate law. We're looking for real estate matters. We got attorneys, we got paralegals. We're all about the transaction of real estate. Well, probate is typically where real estate goes to die. No, just kidding. Just kidding. I'm very hard on probate, but I love the fact that we do have great estate and probate attorneys. I'm just being very mean. Because why not? Let's just laugh at it. Reason we got here is because we were looking at a probate matter. This was a probate matter. This still is a probate matter right now. We're still in probate court. And we were looking at him going into contempt the first time for document production, for the lack thereof, for not following the rule of the document production. And we were taking a gander at how much money is spent going through probate. Well, guess what? That was like 3-4 months ago. We're still looking at this probate case. How much money is the estate losing just by having to fight it out in the first place? You see all those people? We have a guardianship over Dee Warner because she's not there to speak for herself. Reasons are determined that she's deceased. We have a guardianship over the youngest child because she's a minor, so she doesn't have the legalese or the aptitude as an adult to speak for herself, so she has a guardian speaking for her. Then we have a lawyer for the adult children. That's Miss April. Gosh, I think we have one more person. What is John Folderman for? I think John Folderman is the lawyer for the financial conservator, I believe. But he has a role as well. It's like 4 lawyers that's really dealing with the family's point of view in different ways. And one of the reasons why I believe he came on board is because one of the CPAs was like, Dale is not allowing me access to the paperwork. He's not giving me full access to the QuickBooks. I can't even see the accounts. Everything he gives me is a printout statement, but I can't verify what's actually going on right now because printout statements are not to the day, right? Statements are usually weeks, sometimes even a few weeks behind. So I think Folderman is a representation of him. And then we have the defense attorney. The other gentleman was not there, so I was wrong. That wasn't him. But the original defense attorney who was there, who was making our head hurt, right, when we first got in here, just like, he really had me going. And now we have a new defense attorney who has the experience of criminal defense. And that makes sense because guess what? Dale's in jail. Dale is back in jail. He was arrested the day before Thanksgiving for being the suspect in the murder of Dee Warner. So there's a lot going on. We fell into this particular case and I didn't want to leave it unknown. We only came in to kind of find out, like, you know, how much can happen in probate to cost your heirs money, because I want you to make sure you get a trust. I'm trying so hard to get you to get a trust, whether it's with me and my team or someone else. It doesn't matter. I just want you to have a trust, a wills and a trust. A will does not do you much justice. It's a starting point, but it's not the end all be all. You need the trust, and the trust needs to have everything in it. So that's another problem, right? Some people don't put everything in their trust, and you still got to go through probate for the cars, or you go through probate for the antiques and all of the paintings and all the different artwork that you acquired over the years. If it has value, put it in the trust. Okay, so that's how we got here. And I just didn't want to leave us, you know, in the air, because it was getting good, right? It was salacious. It was interesting. It was beyond our wildest dreams. At least for me, I knew nothing about it. Everyone in Michigan is like, where have you been? I'm sorry, I'm a Californian. we have our head in earthquakes and crazy weather right now. I'm sorry, I apologize. Not any earthquake right now, but you know, forgive me. Forgive me, Michigan. I'm so sorry. I'm so sorry, Detroit. I'm so sorry, Lenawee County. I'm so sorry. I didn't know. But now we know, and we don't want to leave it, because the Warner family deserves justice. They deserve to be heard. They deserve to be known across this nation, because they are in representation of something that I'm sure they're not the only ones. I hope they're the only ones to go through this, but I'm sure they're not the only ones. So let it not be for your family. Let this not be their case. Let's learn from the particulars, continue to learn, and continue to do better. Today's hearing was phenomenal for every person that wants to be an attorney. This was juicy for us, you know, but maybe not general public. I understand. I understand. So for if you got some friends that like the law and want to hear how things are argued and get some of those great statements like an affront to the dignity of the court, you know, you gotta love the way attorneys argue, right? It's like, just curse them out already, but you can't do that. You have to be professional. So if you want to learn those type of phrasing and you know friends who might get a kick out of it, go ahead and share for their sake. I understand if this one is not for everyone, but I loved it. I hope you did too. Don't forget to comment in below. Tell me, what do you think? Cruel, unusual, or cruel and unusual? Your opinion still matters. You know, hey, we can have court of opinion now. We've had the court from Judge Sala. Now we can have court of opinion. What is your opinion? Would it be cruel to put him back in jail? Would it be unusual, or would it be both? Okay. All right. Thank you, Lyric Armstrong, your real estate agent and advocate. Go ahead, like, share, and subscribe, and I'll see you in the next video.